Exam Scholar, Real Estate Edition.
Question 1. Which of these instruments does not contain the interest rate, loan amount, term of the loan, and monthly payments? A. Mortgage. B. Deed. C. Lease. D. None of these? Answer. D. None of the listed instruments contain the interest rate, loan amount, term of the loan, or monthly payments. The type of instrument that does contain these is the note. Question 2. Anthony receives a tax bill that is related to cost per front foot and amount of benefit he receives. This type of tax bill would be called A. Eagle. B. Special assessment. C. Front foot assessment. D. None of these. Answer. B. Special assessments are generally repayment to the government for installation of curbs, gutters, and other enhancements. The cost of these is based on the amount of benefit that a particular property receives from the enhancements. Question 3. Retaining a property while at the same time using it as collateral to secure a loan is called A. Promissory. B. Hypothecation. C. Accretion. D. Collation. Answer. B. The act of using property to secure a loan while at the same time retaining the use and benefit of the property is called hypothecation. Question 4. In which clause does it allow for a buyer to be free of recourse in the event of foreclosure? A. Ad hominem clause. B. Dispersal clause. C. Exculpatory clause. D. Extradition clause. Answer. C. An exculpatory clause acts as a non-recourse loan. This means the lender can only look to the property for the satisfaction of the loan. The buyer is not personally responsible for the note. Question 5. Referral fees are legal to be paid if they are given to A. Licensed brokers. B. Licensed agents. C. Anyone. D. None of these. Answer. A. Referral fees are legal to be paid only to licensed brokers. Question 6. The secondary mortgage market consists of which major participants? A. Fannie Mae. B. Ginnie Mae. C. FHLMC. D. All of these. Answer. D. Fannie Mae, Ginnie Mae, and FHLMC are all major participants in the secondary mortgage market. Question 7. What does a general warranty deed contain? A. Covenants that warrant the new owner's undisturbed and clear title. B. Covenants that include provisions of a quitclaim deed. C. Covenants regarding quiet enjoyment. D. None of these. Answer. A. Covenants that warrant the new owner's undisturbed and clear title are contained in a general warranty deed. Question 8. A general agent has full authority to A. Bind the principal to all agreements. B. Act as attorney at law. C. Act in the bounds of power of attorney. D. Only bind principal to agreements with written consent from the principal. Answer. A. A general agent is a representative of a principal that has the full authority to bind the principal to all agreements. Question 9. The income approach to appraisal uses which kind of rate? A. Market. B. Capitalization. C. Index. D. Consumer. Answer. B. The capitalization rate, or cap rate, is used in the income approach to appraisal and is an analysis of how much investors are willing to spend in a certain neighborhood in return for a certain amount of income. Question 10. Which of these is an example of a general agent that has the authority to make binding decisions on behalf of the principal? A. An attorney at law. B. A real estate agent. C. A real estate broker. D. A property manager. Answer: D. A property manager is a good example of a general agent who has been empowered to make binding decisions on behalf of the principal.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. A buyer of a residence, prior to the close of escrow, asks the broker for permission to move into the property. The broker should A. Deny the buyer permission. B. Grant the buyer oral permission. C. Ask the buyer to sign a lease for the property. D. Obtain written consent from the owner. Answer: D. Prior to the close of escrow, the seller is still the owner, therefore, the broker should get written consent from the owner before allowing a buyer to take possession. Question 2. An alienation clause provides that A. The principal amount of the loan, plus accrued interest, is due in the event of the sale of the property. B. The mortgage is security for a promissory note. C. A lien can be placed on the property that takes precedence over a prior recorded trust deed. D. None of the above. Answer: A. Also called due on sale. It states that the lender may demand the loan plus accrued interest be paid in full in the event the property is sold. Question 3. If a man has a freehold estate, which of the following would result in his having a less than freehold estate? A. Sale and leaseback. B. Selling the mineral rights to a third party. C. Giving a leasehold interest for 5 years. D. Granting a life estate. Answer: A. A less than freehold estate is a landlord/tenant arrangement. Of the choices offered, only a sale leaseback would result in a less than freehold estate. Question 4. Broker Young, as an agent, showed a property to James. James signed a deposit receipt which contained the following words: buyer to accept the property in an as-is condition. Broker Young knew that the plumbing in the property was in a major state of disrepair with parts missing, but he did not tell James. The problem with the plumbing would not be apparent to an ordinary, prudent person. If James sued the seller for damages for fraud, the court suit would probably be A. Unsuccessful because the as-is provision in the deposit receipt shows that there is a mutual understanding of possible defects. B. Unsuccessful because the deposit receipt specifically state buyer to accept the property in an as-is condition. C. Successful because the duty to disclose a material fact cannot be avoided by an as-is provision under the stated circumstances. D. Successful because as-is refers only to obvious defects. Answer: C. The Real Estate Commissioner and the courts are very protective of consumers. Therefore, they will not allow an as-is clause to be valid except for obvious defects, which any reasonable and prudent person could discover. Question 5. To alienate title to real property, one would A. Encumber it. B. Place a homestead on the property. C. Convey the title. D. Cloud the title. Answer. C. The term alienate means to transfer or convey. To alienate title means to convey it. Question 6. Real property would include A. Real property tax lien. B. Trust deed. C. Crude oil which has just reached the surface in a pipe drilled beneath the land. D. None of the above are real property. Answer. D. None of the possible answers to this question is real property. A tax lien and a trust deed, although having to do with real property, are not real property. Oil which has been captured is personal property. Question 7. Which is true concerning an option? A. Title acquired by exercising an option usually dates back to the time of the option and cuts off intervening rights acquiring with knowledge of the existence of the option. B. Only the optioner is bound to a sale. C. The optionee has no interest or estate in the land. D. All of the above statements are true. Answer. D. All of these statements are true. Question 8. Abel buys Blackacre from Baker, taking title to the property subject to the existing loan. The person primarily responsible for the repayment of the loan would be A. Abel. B. Baker. C. Either Abel or Baker. D. Neither Abel or Baker. Answer. B. When a buyer takes title subject to the loan, the seller retains the responsibility for the repayment of the note. The buyer takes no responsibility for the note. The buyer can lose a property by foreclosure because a property was bought encumbered with loan, but after the foreclosure, if there is a deficiency in the process, the buyer is not liable for that note deficiency. Any suit would be against the seller for the deficiency judgment as the buyer's name does not appear on the note. Question 9. A lessee's interest is A. Personal property. B. A chattel reel. C. A grant to use property for a period of time which reverts to the grantor at the expiration of the term. D. All of the above. Answer. D. All three choices refer to the lessee's interest in real property. Always keep in mind that a lessee's interest is personal property known as chattel reel. Question 10. An apartment owner was figuring his net income for income tax purposes. He took the gross income and deducted certain expenses. Of the ones listed below, which could he not deduct? A. Depreciation. B. Interest on loan for purpose of purchasing the property. C. Management expenses. D. Cost of offense. Answer. D. Offense would be a capital improvement. The cost of it should be added to the cost basis of the property and depreciated. Question 1. In portfolio risk management, a lender considers A. Diversification. B. Liquidity. C. Reserves. D. All of the above. Answer. D. In portfolio risk management, a lender determines what type of loans to have in his portfolio. Factors are: how quickly can I sell these loans? What are my reserves? How diversified are these loans? Are they all business? Are they all residential? Are they a mixture of business and residential? Question 2. You sell a note with a face value of $12,000 for $10,000. You are A. Discounting the note. B. Amortizing the note. C. Committing an act requiring a real estate license. D. Committing fraud. Answer. A. Anytime you sign a note or sell a note and the amount you receive is less than the account stated on the face of the note, you are discounting the note. Question 3. An able buyer means one is A. Financially able. B. Having the ability to obtain the necessary funds to purchase real property. C. Having the ability to obtain necessary financing. D. Any of the above. Answer. D. Any of these would indicate an able buyer. Question 4. The right to foreclose a trust deed, under a trustee's power of sale, outlaws A. In 4 years. B. In 3 years. C. In 2 years. D. Never. Answer. D. A trust deed is not a contract, but rather a conveyance of the naked legal title with the power of sale from the trustor to the trustee. Therefore, the trustee retains the right to sell the property under the trust deed at any time for the benefit of the beneficiary. The conveyance has been performed and thus is not under the statute of limitations, therefore, it never outlaws. Question 5. Broker Styles took a listing from a seller using the standard listing form. 1 week before the listing expired, the broker informed the seller that he had a prospective buyer named Bennett. After the listing expired, the seller listed with broker Johnson. Johnson showed the property to Mr. Bennett and obtained an offer that was accepted. Under these circumstances, A. Broker Styles gets a 6% commission. B. Broker Johnson gets a 6% commission. C. Both brokers get a 6% commission. D. Broker Styles gets a 3% commission and Broker Johnson gets a 3% commission. Answer. B. In the safety clause of the standard listing form, Broker Styles would agree to relinquish his safety period if the property were listed with another broker. Question 6. A loan created with more than one borrower is usually added to the promissory note for the protection of the lender. A. Beneficially. B. Jointly and severally. C. Universally. D. Unconditionally. Answer. B. When there is more than one borrower on the note, the promise and obligation to pay that balance is the responsibility jointly of all the co-borrowers, and also each individual is severally liable for the full debt. Severally, in law, means individually. Question 7. Mr. and Mrs. Johnson, who had been shopping for a new home, found one that they liked very much, but because they felt the property was overpriced, they decided not to buy it. Their reason for not buying was probably based upon the principle of A. Conformity. B. Substitution. C. Highest and best of use. D. Anticipation. Answer. B. It must be assumed that our buyer has found another home that was equally desirable but at a much lower price. This is the idea behind the principle of substitution. Question 8. When a broker misrepresents his principal's property to a buyer, he could cause his principal to be subject to A. A court action for damages by the buyer. B. A rescission of the sale by the buyer. C. Civil responsibility for compensating the buyer for misrepresentation of the broker. D. Any of the above. Answer. D. The principal is responsible for his agent's actions. If misrepresentation occurs, there should be a rescission of the sale or civil court action for damages. Question 9. An owner of a 5-unit apartment building that is located within the city limits intends to convert the building into 5 condominium units and offer them for sale to the public. Under these circumstances, the developer A. must obtain a public report from the Real Estate Commissioner under the Subdivided Lands Act. B. must file a map with the city under the provisions of the Subdivided Map Act. C. is exempt from the Subdivided Lands Act and the Subdivision Map Act. D. must comply with the Subdivided Lands Act and the Subdivision Map Act. Answer: B. Any type of subdivision located within the city limits is exempt under the Subdivided Lands Act, but a condominium conversion of 5 units or more is covered under the MAP Act and must be filed with the local authorities. Question 10. After acquired title is conveyed in any trust deed for the benefit of the beneficiary, it conveys A. personal property later affixed to the real property so as to become real property. B. improvement built on the land after title is acquired. C. additional land acquired afterward by the truster. D. all of the above. Answer: D. After acquired title refers to title to fixtures or other real property items that become part of the land that is securing the existing trust deed. If a lot serving as security for a loan made 10 years ago has land affixed to it, that land becomes encumbered with the lien made 10 years ago. If additional improvements, such as a swimming pool, added bedroom or new landscaping are added to the real property, they to become encumbered with a trust deed lien made 10 years ago. Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer: B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. an endorser. B. a maker. C. a payee. D. holder in due course. Answer: D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should: A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer: C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. subordination. B. escalation. C. acceleration. D. alienation. Answer: C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, the entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer. C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases, A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer. B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer. A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called A. Gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer. D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer. A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. What does an appraiser do? A. Establish market value. B. Establish estimated property taxes. C. Verify building codes are in conformance. D. Provide written documentation on the state of the property. Answer. The primary task of an appraiser is to establish an estimate of market value through the analysis of data. Question 2. What type of estate is an interest in real or personal property that is limited in duration to the lifetime of its owner or some other designated person or persons? A. An estate for years. B. A leasehold estate. C. A land estate. D. A life estate. Answer: D. The type of estate that is based on the lifetime of its owner or designated third party is called a life estate. Question 3. If a married couple purchases property as tenants by the entirety, neither can obtain a court order for A. Partition. B. Separation. C. Estimation. D. Accrual. Answer: A. Neither person can obtain a court order for partition when a married couple purchases property as tenants by the entirety. This is different than other forms of ownership by a married couple. Question 4. What is the best way to determine if a neighboring property is encroaching on another? A. Obtain a court order. B. Visually inspect the properties in question. C. Obtain a survey. D. Compare land maps of both properties. Answer: C. The best way to determine encroachment is to obtain a professional survey of the property lines. Question 5. Henry is the seller of his home, which was built in 1978. What booklet is Henry required to give a potential buyer? A. Environmental hazards disclosure. B. Lead paint information. C. Flood zone disclosure. D. Asbestos warnings guide. Answer: B. If Henry owns a home that was built in 1978 or earlier, he is required to give any prospective buyers or tenants a lead paint information booklet. Question 6. When a corporation holds title to land, under whose or what name holds the title? A. The board of directors. B. The shareholders. C. The corporation. D. The charter. Answer: D. Since a corporation is a fictitious person, the corporation holds property title in the name of its charter. Question 7. An African American family is looking to purchase a house. Their agent has been showing them properties for weeks, all of which are in predominantly African American neighborhoods. This would be an example of A. Blockbusting. B. Steering. C. Isolating. D. None of these. Answer: B. This type of behavior would be an example of steering and is in violation of the fair housing laws. An agent must show homes in any areas in which the client can afford. Question 8. One of the jobs of a property manager is A. Maintaining the property while managing finances. B. Settle disputes with neighbors. C. Personally evict tenants that have not paid rent. D. Operating a log of events on the property. Answer: A. One of the major jobs of a property manager is to maintain the property while managing the financial side of the operation for the property owner. Question 9. If Ivan owns property but has no heirs or will when he dies at age 86, who owns the property thereafter? A. The next blood relative. B. The federal government. C. The state government. D. None of these. Answer: C. In a case in which a person dies owning property but has no heirs or will, property ownership reverts to the state. Question 10. In a case in which a person dies with no will and no heirs to their property, this is called A. Reversion. B. Escheat. C. Accretion. D. Reverse ownership. Answer B. The state becomes the owner of a property if the owner dies with no will and no heirs through the power of escheat.
Exam Scholar, Real Estate Edition.